Case number 108550, State of Kansas v. Keenan.
Your Honor, I would like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. May I proceed?
You may.
This was a matter where law enforcement was contacted by an independent witness indicating that Mr. Keenan had been driving under the influence of alcohol, also that there had been an alleged violation of a protection from abuse order. Law enforcement contacted Mr. Keenan when he was arriving at his home. At his home, Mr. Keenan exited the vehicle when the officer made contact with him. He had removed his 4-year-old son from the vehicle, who was estimated to have weighed approximately 40 pounds, placed him on his shoulder, his son's head resting over the shoulder. He was also then on his cell phone. As he began walking towards the home, he stumbled. It was in December. The weather was noted to be sleeting at that time. The officer indicated that she smelled an odor of alcohol about Mr. Keenan. He asked permission if he could enter into his home. She granted that permission. During the time that he was walking in, she had requested a backing unit, which would be standard practice. That second officer then arrived at the scene. As Mr. Keenan was to enter his home and cross the threshold, she stopped Mr. Keenan and asked if they could accompany him inside. Mr. Keenan denied consent for them to enter the home. He then proceeded in, under the consent that she had previously given him, to place his child down in bed so that he could then return and discuss with them regarding a potential DUI investigation, as well as their concerns of his violation of a protection from abuse order that had been in place. The officers at that time entered into the home following Mr. Keenan, where he placed his child down to bed, and they proceeded with their investigation there inside the home. Trial counsel filed a motion to suppress. That motion to suppress was based upon the idea that the officers did not have, 1, probable cause, or 2, exigent circumstances to enter into the home, as Mr. Keenan did not give them consent. Primarily, our issue that we had first raised was, and I'm sure as the court can recall, the district court judge that denied the motion to suppress was very clear in his ruling that he had applied a reasonable suspicion standard rather than the probable cause standard that should have been applied to accompany the exigent circumstances to determine if the officers had the authority to enter the home with Mr. Keenan. The Court of Appeals opined that it was harmless and wrote that they applying the wrong ground or assigned erroneous reasons for the decisions, but the district court reached the correct result. That was contained in the opinion that we had filed the petition for review from. We believe that when looking at this, the Court of Appeals also erred in that analysis, in that this was not a matter where we had applied the wrong set of facts but reached the right conclusion, but the court applied the wrong standard. And that standard of reasonable suspicion, as supported by the case law, is a much lower standard than probable cause. The courts are aware that the requirements and evidence of a probable cause standard to show that is less demanding. Those facts can be less reliable. We believe that when looking at that...
Didn't the Court of Appeals, you can have a right for the wrong reason even when you have legal error, can't you?
They did note that in their opinion, yes.
Okay, so isn't that what the Court of Appeals would say that it did? That it recognized legal error, but found that the district court was right for the wrong reason because, in fact, probable cause was present?
We believe there wasn't probable cause in that.
I know that's your position,
yes.
But that's what they said.
That is what they said,
They
correct.
didn't just forgive the error and go on blithely down the road.
No, and we believe that the district court never made the finding of probable cause based upon the supporting facts. We have found that even this court has noted that when applying the wrong standard in something as a departure, in a Jessica's Law case, where we have seen the court using the Jessica's Law, the non-exclusive list of departure factors rather than the Jessica's Law list of exclusive factors, this court has found that using that wrong standard is reversible error to send that back. regardless that it's both non-exclusive lists and those that court could have found those still to be substantial and compelling reasons. The wrong standard was applied and stated then by the court, and that has been grounds to remand to allow the court then to review that motion under the proper standard.
But does that require additional facts? Isn't the determination of whether a set of facts constitutes probable cause a legal question?
It is a legal question.
And we don't have any factual disputes here. It's just whether those facts fit into the category of probable cause as well as reasonable suspicion that the district court found.
That would be fair as well.
So why do we need to remand? Why can't the appellate court take the undisputed facts and determine whether that fits probable cause?
They certainly could, and I also believe, based upon the review of the opinion, the appellate court was slightly confused in some of the factual underpinnings that they had used. They had noted that Mr. Keenan's eyes were bloodshot at the time as a reason for the fact that Mr. Keenan would have had probable cause to determine possibly that we needed to further a DUI investigation. If through a careful reading of the transcript from the trial, you will note those observations were not made until the officer actually entered into the home. So many of the observations that the Court of Appeals relied upon occurred after they had entered the home and then would have then supported further investigation of Mr. Keenan. Prior to entering the home, they had Mr. Keenan stumbling on a sleeting night, carrying a 4-year-old, 40-pound child while he was on the telephone, and they had an independent informant who I believe was his ex-mother-in-law who telephoned the police to believe that he was under the influence of alcohol.
Wasn't there an odor of alcohol as well?
There was an odor of alcohol. There was also no bad driving. There were no bloodshot eyes that were noted while they were outside.
Let's just talk about what they did have. You just listed 3 things. You had the stumbling.
Yes.
And you say that was mitigated by carrying a 40-pound child and talking on the phone, but he was stumbling, and the weather.
Yes.
He was stumbling.
Stumbling.
There was an odor of alcohol.
Yes.
An exit from his truck, right?
Yes.
And then there was a tip from a known person who had observed him and smelled him and seen him.
Well, I don't know that there was any evidence that they had smelled to the extent of what the tip was
They had a tip
from.
from somebody who said he's drunk.
Drunk. Yes, they did.
Stinking drunk.
Absolutely. Mhm.
Okay, so that's quite a bit more actually than a lot of officers have.
And I think at that point, if the officer wanted to stop him from entering his home, she absolutely could have, but she granted him permission to go in. He was cooperative. He wasn't combative, as many people who are under the influence of alcohol are. It was clear his concern was to take care of his child and that he was going to return.
Okay, but I'm talking about probable cause first, because that was the subject we were on.
And I think if she had determined she had probable cause at that time to stop him from going in, she would have. But she gave him permission to enter the home, and I think it's very important under the idea that she gave him the permission without saying it was qualified by the idea that she had to accompany him.
Do we know that, or is that an
That is in the
inference that
report.
you're drawing?
No, that is actually in the trial transcript, that she gave him permission to enter the home.
Well, I know, but the reason that she did that, do we know that?
No, we don't know
I mean,
specifically.
she may have also had as much concern about the child being out in the sleet as the father did.
I would hope so.
And so that might have been the reason she granted permission.
She might have, but there was also a secondary officer who could have helped care for the child, or they could have set the child down somewhere else. When she gave him permission, it wasn't a qualified permission of, well, I'm going to do this, and he had indicated he would return. And so there was no reason at that point to disbelieve anything else he had said, because certainly as you look at some of the factors that the Court of Appeals adopted, they believed that when he told the officer on his way into the home, he was the only person in the home. So we've adopted that fact to be true. But then we question whether when he says, I'm going to put my child down, which we verify he has a child, he is in fact carrying and entering the home, that he would then return.
Did he say he was coming back? Did
Yes, he
say,
did.
I'm going to put the kid down?
He did. Yeah, he said that I would go lay my child down and I would return, but he did not want them coming in the home.
Was any evidence generated after the entry into the house that could not have been generated if it had been on the porch, if he'd come back out?
I think that certainly he could have performed the field sobriety tests out on the porch. I can't speak to the lighting in the front, so I wouldn't know if she could make the observation of his eyes, but I'm sure she would have had a pen light or some kind of flashlight to be able to do that. I don't believe there was any evidence she gained inside except the idea that there was no obvious bottles of alcohol that were in plain sight or any of the things that would have...
Those don't tend to show he's guilty of DUI. They tend to show
No.
the opposite, if anything. My colleague's asking you, what did they get as a result of going inside that they couldn't have gotten standing on the front porch?
I don't know that they gained anything from going inside that they couldn't have gotten standing
So
on the front
why
porch.
is this a residential search? It's a search of the person. It just happened to
Because they entered his home
occur.
without...
It happened to
consent.
occur
Counsel, let him
inside.
finish his
Oh, I'm
question.
sorry. Yeah, I believe it's because they entered the home specifically without consent when he had said they are not free to enter the home.
But I guess what I'm asking, if they had stepped over the threshold and reached into his pocket and searched his person, is it a different search than if they had done it on the porch before crossing the threshold? If you're making a personal search, does it matter if it happens inside or outside?
I believe it does.
Did you, what would we rely on? Do we have some law that says that the search of the person is different if it's inside a house?
I think we have the body of case law without looking at anything specifically because obviously that wasn't an issue that I had prepared for today. I think we have the idea of the case law, which is if he were already inside the home and the officer wanted to search his person, the officer would need a reason to enter the home. The officer simply couldn't enter the home under the guise of saying, I'm not coming in to search your house. I'll ignore what I see in plain view, but I do need to pat you down for officer safety while we talk through the door. There isn't case law that I'm aware of that allows them to cross that threshold for an actual physical pat down of the officer during that time, or of a suspect during that time when they have crossed the threshold or inside their home. I believe at that point they have the greater protection of being inside of their home subsequent to the Fourth Amendment.
Were any of the exigent circumstances related to other aspects other than the DUI and the violation of the protection order? I mean, the underlying crime. I'm thinking that child endangerment would certainly be a factor here when a person picks up, it's reported that the person's drunk, picks up a 4-year-old, puts him in his car and drives, that's endangering a child. Was that theory ever articulated to the court, or that concern ever articulated to the court that would serve as a separate basis for entering the home?
I can tell you that matter was not originally charged in the complaint. To that extent, there was nothing specifically under the idea that it was for the child endangerment or child welfare. Without ever looking at that issue as well, I do know under 8-1567, the DUI law has a special provision
Right.
with an enhancement, and so I couldn't speak to if we could charge both the criminal endangerment as well as then using the enhancement in the statute. But everything that the officer testified to and knew at the time was related to the protection from abuse order as well as to the DUI. But there was no theory furthered by the state or considered by the district court that this related to any issues of public safety to the child or the child endangerment. I think the child was, I think as I've read through the trial transcript, as I was not trial counsel, I believe that it was very clear that the officers needed the child obviously off of my client's shoulders and in a position that the child was safe and secure before they could further their investigation into the DUI.
Counsel, we've talked to you a bunch about probable cause. I want to talk to you about exigent circumstances for a minute. As I remember the case, the Court of Appeals relied on two types of exigent circumstances being in existence. One was the possibility of destruction of evidence, somehow corrupting whatever evidence could be gathered from him about the alcohol consumption and degree of intoxication, and the other was hot pursuit. I'd like you to address those to the extent you want to on your opening argument, and I also want you to address the idea that the police may have created the exigency here by allowing him to go inside the house.
Certainly under the first with the possible loss, destruction, or concealment of evidence, the idea behind that is very straightforward, that if Mr. Keenan had entered into his home and did not return and the police were not permitted to enter, then if Mr. Keenan had alcohol inside, which was unknown, as from the facts, there was no alcohol in plain view, there was no alcohol seen, Mr. Keenan may have had an opportunity to ingest alcohol very quickly in an effort to skew any blood and breath alcohol testing that may have occurred. The idea is that he would destroy the evidence, or the evidence would no longer be reliable because there would no longer be the window, and the officers would then be aware that he had ingested alcohol after he had finished driving.
And why is the Court of Appeals not right about that? That that's an exigent circumstance that justified entry?
I believe, one, because factually, when the officers were in the house, as we had discussed previously with some of the questions, they were in the kitchen. They went from the bedroom and into the kitchen with Mr. Keenan and did not see any of that alcohol.
But they didn't know that when they stood on the front porch.
They did not know that.
Don't we have to judge the existence of exigency at the time they're standing on the porch making the call whether to follow him in?
I would think so.
So
I would also
what
think
difference
that
does it make whether it was or was not there later?
I would think that if the officer didn't want him to enter, and these are officers, as you can see from their training and experience testimony through the trial, have done DUI stops before, and they were concerned about this, they wouldn't have given him permission.
I understand that we're kind of
And
doing some reconstruction of the psychology of the officer, but I'm talking about what did they know? What objective facts did they know as they stood there on the porch?
they knew that they had a possible DUI where they didn't witness the driving because of the time they encountered him. They had an independent witness who had said that he was intoxicated. She smelled an odor of alcohol, and he stumbled while coming in, as we discussed, with the inclement weather and carrying a child.
So wasn't there the possibility as they stood out there that he might go inside and drink a bunch more and queer their DUI investigation?
I guess we are also doing the same thing of the psychology of what Mr. Keenan was going to do, because
I'm talking about
that,
what they know then. They know there's that possibility. Is that possibility adequate or inadequate as a matter of law to serve as an exigency to enter the home?
I believe it's inadequate at that particular point.
Other than your belief, what do you have to give us?
From what I have reviewed, the body of case law is not necessarily in my favor on that point.
Okay.
As it relates,
Let's talk about hot pursuit then. What about hot pursuit? Does this qualify as hot pursuit? Does the Court of Appeals seem to think it did or not?
the
And
Court
if
of
not,
Appeals
why not?
did. I don't believe, specifically, I don't believe that this qualified as hot pursuit. When looking at this, we had looked, and the parties had cited the Dugan case, which I'm sure the court is familiar with, and Mr. Obermeyer had filed a supplemental notice that it also cited some matters out of, I believe, off of the East Coast, perhaps Massachusetts, a Commonwealth case. When looking at all of those particular matters, the officers were actively engaged and were in a position of asserting their authority and attempting to stop someone who did not stop. While I understand that Dugan is very clear that hot pursuit doesn't require a lengthy car chase, but it could be something as simple as telling him not to enter his home, and then he were to cross the threshold and enter the home while the officers were exercising their authority. In this situation, the officer was not in hot pursuit. She was investigating the potential information that she had received through dispatch and had never told Mr. Keenan he could not go into his home. In fact, she specifically told Mr. Keenan he could enter his home and put his child down, and then as he was entering, stopped and asked him if it would be all right that she enter. Certainly in a position, if she thought she were in hot pursuit, she wouldn't need to ask Mr. Keenan's permission to come into the home. And Mr. Keenan then denied it. I believe that when looking at the totality of those particular circumstances and applying it to the Dugan case, Mr. Keenan was not in a situation where this officer was in hot pursuit of him. In fact, he was in compliance with the things that she had said. He was submitting to her authority, he was granted permission, and that permission was never revoked. But she had never told him, you can't go in, or I need to follow you in if you're going to take your son in and lay down. I think certainly the officer could have expressed and exercised greater control because Mr. Keenan had yielded to that control, as noted by the Court of Appeals. And so I don't believe this is actually a circumstance where hot pursuit is appropriately applied by the Court of Appeals in this particular case.
So it's not,
Oh, excuse me. Go ahead.
so it's not even lukewarm pursuit?
I don't believe this is it. I don't believe this is an instance of lukewarm pursuit. I don't know that you can
Is
pursue
it your
someone-
position it's no pursuit whatsoever because of the permission that was asked for and granted?
Yes.
All right.
And by the same token, to the extent there was an exigency, in other words, possibility that evidence would be destroyed or some kind of hot pursuit ongoing, it was because the police let him go in.
Yes,
It's a police-created exigency situation.
it is.
Okay.
Doesn't the officer have to go inside to ensure the child's safety?
I don't believe
Because
so.
otherwise, you're saying that the officers have to stand out on the porch, let this guy go in with the child, shut, and create a situation where the door gets shut and locked, and he's in there in the house by himself with the child.
I believe if the officers had concern for the safety of the child to the extent that the court has suggested here, the officer should have never let him enter the home with the child. When looking at what the officers did after he laid the child down, he went to the bedroom where the child would sleep. He laid the child down, he shut the door to that, and the officers never went back into that situation again.
They're already inside, though. I mean, what they've done is prevent some sort of safety issue, like a hostage situation or something. I mean, really, the officers are supposed to stand out on the porch, let this guy take his child inside, and create the possibility that we've got him on the other side of a locked door with the child. I mean, it seems like you're asking a lot of the officers in this circumstance. When it's bad weather, there's ice, there's so much ice, people are stumbling around, slipping, trying to get into the house, and the officer's supposed to stay outside in the cold. I mean, they're really just, it seems like they're trying to accommodate a bad situation, and now we're trying to get really technical about what was said and who thought what when, as a part of the exigent circumstances.
So if I'm understanding, this would be separate, obviously, from the destruction of evidence as well as the hot pursuit.
Yeah.
This would be an idea that the officers are permitted to enter the home based upon public safety or welfare of the child without any other factors.
Yeah.
And,
Well, they've got a protection from abuse order. They don't know too much about it, but they've got something out there.
but they do know the protection from abuse order is not related to the child because they had obviously checked into the protection from abuse order prior to responding to the call, so they wouldn't have been allowed Mr. Keenan to have possession of the child or even take his child into the home if that's who the order was from. Certainly based off the qualified informant who was known to them, who has a relationship with Mr. Keenan, that information would have been relayed and probably would have been the first information relayed to dispatch if he took a child where there was a protection from abuse order that he was not to have them. And we would be dealing with a much different charge, perhaps a kidnapping, there would have been Amber Alerts and so forth. I think what we're looking at is the officers had enough time to assess the situation because we have to use the information the officers had when they allowed him to go in the home. And they allowed him to go in the home, gave him permission to take his child in and put his child down because they did not assess any danger to the child. And if the officer had, the officer could have easily stopped the child from doing that. We spend a great deal of time hearing about the officer's training and experience in the cases that we do on the in criminal court, and this would be something the officers would not only be very alert to, but would also be trained in doing so. So I believe the officer, by stating he was free to go into the home without a qualifying statement of, with one of us present, to put your child down, had already assessed that situation, because I think the officer would be derelict if the officer did not take that into consideration first and foremost in those circumstances that the child would be safe.
I thought you said that the part of the motivation to let your client go in was to avoid a confrontation while he's holding the child.
Well, I don't think one can do field sobriety tests while holding the child.
No, I agree. Not only field sobriety, but also have any kind of extended engagement with him while he's holding the child outside in the sleet, cold weather. Kind of forces a situation where we don't want a confrontation, we'll let them go in. And wasn't that a part of the
I think the officer,
consideration?
I do believe the officer wanted to allow the child to be cared for and to put it in a situation that she could perform her duties in investigating those allegations properly and in compliance with her training. And so I believe the officer did, in that situation, the appropriate thing in allowing him to take the child inside and put the child down. I also believe if the officer thought that the child was in any danger, she would have never allowed him to do that, and certainly could have taken custody of the child and put him inside of her police cruiser where he would be secure. The car would be warm. There was another officer on scene. So there were certainly alternatives if she really believed the child were in danger to protect the child from Mr. Keenan without much additional effort, such by simply taking custody of the child and placing him in the car. That would have protected the child, kept the child free of the elements. The child could have laid down and slept on the seat, and we would have been in a position that she would not have needed to allow Mr. Keenan to go back in the home. But after assessing the situation, she allowed him to go into the home unaccompanied with no qualifying requirements that he may enter as long as he were to return.
I thought the officer went in with him,
They did.
so that he was never
He
allowed
was.
to go inside the house unaccompanied.
He
They
was-
were right there.
He was permitted by her statements, not by her actions.
Any further questions? Thank you, counsel.
Good morning. May it please the court, the state appears by Stephen Obermeyer. If I could just follow up on the last topic. What I'm hearing is what the police should have done is to say, Mr. Keenan, we're not letting you take 4-year-old Greggy in the house, keep him in the car, do the field sobriety tests here. He refuses that. He refuses a toxilizer. Mr. Keenan, you're going to the station with us, and we're bringing Greggy along with, and he can stay in one of these rooms while we get somebody to take care of him while you get processed and go to jail.
Did the state rely on public safety or child endangerment as a basis for the officers entering the house?
The child endangerment was not articulated at either the motion to suppress or at the preliminary hearing or the trial. However, I do...
Well, there's your opposing counsel said public safety, but I think it's really called the emergency doctrine, isn't it? That you can enter a house, you have probable cause exigent circumstances, or the emergency doctrine. And the state never relied on the emergency doctrine here, did it?
Did not.
Okay.
Although I recall Officer Madel testifying that she did not want to leave the 4-year-old there in the house with
the point
drug.
is, the issue of whether the emergency doctrine applies under these facts is not before the court today, is it?
I think if the court finds that those facts fit the emergency doctrine, that would
Well, that
fit.
issue was not preserved for appeal.
If we get to the very issue that was raised, and that was one of my issues, that there was no contemporaneous objection to any of Officer Madel's testimony, most of the direct of Officer Hinkle's testimony, and we finally see an objection, a contemporaneous objection, when the state offers the half-empty bottle of Irish whiskey in the car and the 2 bottles of beers, or if you're an optimist, a half-full bottle of Irish whiskey.
The Court of Appeals characterized it as a tardy objection, right?
And so we're going to consider it anyway and disregard what 6404 says about a contemporaneous objection after all this other stuff has come in. And by the way, defense counsel offers State's Exhibit 3 and calls Officer Madel to ask about some of the statements that the defendant made on the tape, that he had bad knees. That's the explanation. And the defendant wanted to testify. So, this is going to come in at some point, I would think. But I think the comment that accommodating a bad situation was probably correct. We'll let the child be laid down and then talk with the defendant. I think one of the officers stayed while a relative came to get or to take care of Greggy at the residence. As far as probable cause, I think there were about 8 issues, and if you listen to the 911 call by the concerned grandmother, who basically said 4 things. My grandson was taken by his father at 11:15, and he was very drunk. He's stumbling drunk, and that's what Officer Madel also saw at the residence. He's very drunk and driving, and I didn't know it was sleeting out there on top of it. And the fourth thing she said was, I want him to be stopped on a DUI. And Officer Madel corroborates that there was a strong odor of alcohol on his person and in the truck. Keenan stumbled as he carried the child, had a hard time walking in a straight line while carrying his son, and the officers were under the impression that he had violated a protection from abuse order.
And so you're saying at the point that there was contact at the residence before the house was entered, that the police had probable cause. Is that what you're arguing?
I think once the officer encountered him and smelled the alcohol and saw him stumbling, they had probable cause. They probably did have probable cause just based on the phone call to arrest for the DUI, and then there was also the protection from abuse issue. But yes, I think so.
So you're saying that they didn't need the additional evidence they obtained by entering the house, and so that's harmless, or what? I mean, they didn't arrest him. If they had probable cause, they could have arrested him on the porch, correct?
Correct.
And they didn't. So how does it play into our calculus? The issue before us is the entry into the house. How does the fact that there was probable cause before the entry in the house play into what we're deciding today?
Well, I think that there was the probable cause. The fact that they didn't, I think, could be seen as more of just an accommodation to what to do with the 4-year-old while they're going to deal with him, and so I don't know if it's a harmless error, but it's certainly, if you look at the exclusionary rule cases, was this an egregious violation of the Fourth Amendment? Is it shocking what the police did in that case? And I would think to have handled it otherwise and take Greggy downtown with his dad is harsher than that. But and once inside, the police didn't seize anything in there. That's why I thought it was more like the United States versus Santana, that a defendant can't flee into the house, or in this case say, hey, can I go in the house and do something else, and that the police can't pursue with that. And I cited in the 609 letter the Commonwealth versus Jewett case that had some good language, that law enforcement is not a child's game of prisoner's base or a contest with apprehension and conviction depending on whether the officer or the defendant is fleetest of foot. That this was set in motion outside the house, and that's why the police let him go inside to put the 4-year-old in the house.
Counsel, I've got to clear up my notes here.
Okay.
I've got a note here about slurred speech. That was observed after they were already in the house, is that right?
I'm not sure. Okay. I don't know if there was much conversation outside or not, so that might have been inside.
Well, we know he had to ask permission to go inside, and I just can't tell from my note whether it was in or out. So
I don't.
Maybe so we'll find out.
I'm sorry.
Thank you.
Mr. Obermeyer?
Yes.
I'd like to focus, if we could, for a moment on the two specific exigent circumstances or types of exigent circumstances the Court of Appeals relied upon. The evidence destruction possibility, and I guess I'll stop there for a second. It is just a possibility, really, at the time the officers are on the porch. It's just a possibility that he could somehow corrupt the DUI evidence while he's in the house. They don't know anything about what's in the house, right? So the best we can say is it's a possibility.
That's correct.
Is a possibility adequate under the law?
It's more than a mere hunch, maybe. I think that it was a concern.
I mean, the quintessential exigent circumstances case that depends upon destruction of evidence is they hear the toilets flushing,
Right.
right? And that, we didn't have that situation. We had him carrying the kid inside. They didn't know whether he had alcohol in there or did not. You know, they just don't know, right?
Right.
Okay, putting that aside, I want to return to hot pursuit, the idea of hot pursuit.
Okay.
I think I heard you answer my colleague's question, say they had probable cause on the porch, they could have just arrested him there. Given that, can we fairly describe what was happening as a hot pursuit or not?
Well,
They could have stopped the hot pursuit right then, according to you, because they already had probable cause.
they
And he
could.
gave him an opportunity to stop the hot pursuit by asking permission to go in the house. And I understand the humanity of letting him take the child inside when it was sleeping. I understand all of that. But can it truly be hot pursuit when he asked permission to go in and they let him go in? Isn't that more of a police-created hot pursuit?
When I think about the cases on the police creating a situation, I know there was a U.S. Supreme Court case where police are knocking on the door and they thought they heard something inside and then they went in. So that's kind of a police created entry.
I think we have a case where the finger got held over the peephole. Remember that case?
I don't remember that case.
Okay.
But what they did encounter him in a public place, bless you, and I think we're able to maintain contact with him. He, unlike U.S. versus Santana, he didn't have drugs on him. They just thought he was under the influence, and
He had drugs in him.
he had drugs in him, and it's. You know, they didn't know whether he was going to come back to the door. I mean, they say, yeah, sure, go on in. We'll just wait out here.
Do you agree with your opposing counsel that he said he was coming back?
I don't recall that.
Okay. I didn't remember that either, but I thought maybe you would.
And I think there's an audio of the encounter, and I don't recall that.
Okay,
on there.
so just assume with me for the moment that possibility may not be enough for destruction of evidence, so
Okay.
that form of exigent circumstances may not work for you here. Hot pursuit is at least a little dodgy because they gave him permission to go in without securing his agreement that they could follow him when he went in. So we may have a problem. We may have a problem on the entry to the home. I'm intrigued by my colleague's other suggestion that it may not matter because he could have been arrested on the front porch. They didn't get anything from inside the house, you mentioned.
Right.
The fact that they discovered booze in the car, one would think would have followed from any DUI investigation, even one conducted in the sleet on the porch, not just from what they did in the house. Is that all? Would you say that all leads us to harmless error?
I think if you find that was a Fourth Amendment violation, and that the contemporaneous objection rule doesn't apply.
We get around that.
But yes,
Yeah.
I think I don't know what they would have gotten. Other than, I mean, inside, I guess there was a slurred speech, but once they arrested him, he's going to still have the slurred speech once inside.
They'd already observed him stumbling.
Right.
Okay, thanks.
So, I mean, I guess there wouldn't be much difference as far as what that evidence was. I think the Court of Appeals looked at the factors under Platten and thought that there was a clear showing of probable cause, strong reasons to believe the suspect is in the premises, peaceful circumstances of the entry are some of the factors. And even though I don't know if the police created it because Keenan's the one who asked to go inside. The police didn't say, hey, let's go inside and talk about this.
But they also asked if they could go in. The officer asked, can we go in with you? And that request for consent, maybe just as belts and suspenders, but it gives the impression that the officer may not have assumed they could automatically enter under the facts. I mean, it gives someone pause at least
Right.
that they ask, can we come in?
Right.
If they had the right to do so in their own minds, why are they asking?
I don't know if they're looking for, we had consent in addition or not, because the fact that they went, like you say, the fact that they went in anyway, I don't think it mattered. But, I mean, here's a case, the court thinks, well, people are always gonna do what police say and give consent. Here's one where it didn't happen, that you have before you, but,
Counsel, one of the questions I mean, if we assume this is a close call, which way to go? But given the ease with which law enforcement can now get search warrants electronically and iPads and all that fun stuff, why shouldn't we err on the side of the sanctity of residential property for Fourth Amendment purposes?
well, because this happened in 2010, I believe, so I don't know what the technology was. And back in 2010, the DUI law was over .08 within 2 hours as opposed to 3 hours as what it was now. But again, I don't know what the whether we had iPads or technology like that. There's nothing in the record on that. And the Missouri case kind of left it on a case-by-case basis and didn't have a per se rule on it. But I don't, we know the Fourth Amendment, you can't go into residences, but this was instigated at the defendant's request, and the police didn't want to be deceived in letting somebody go in there who was intoxicated with a child. Maybe have a child need a care issue. We'll just wait out here for you. Come back out, and then what are you going to do? So I think what they did, as far as the treatment of the 4-year-old and the defendant, was reasonable and not egregious. So I think, and the Court of Appeals said we look at these on a case-by-case basis, and that's why I think in this case that the actions of the police were appropriate.
Counsel, I have one other fact question related to a representation made by your opponent. He said that at the time the police officers were standing outside the house making the call about whether to go in or not, that they already knew the PFA had no bearing on the child, or that the child was not the subject of the protection order. Is that correct, according to your view of the record?
I'm not sure. I would direct the court to page 35, and I don't know if it's the prelim or trial transcript, but the officer Hinkle said the other reason that while we were en route to that call, we were told he had violated a protection order involving another party. So maybe that is another party. Okay. I had the opportunity to read about 3/4 of that report on the way and determined that was, based on what I had read, there was probable cause to arrest him for that violation. So it doesn't sound like it was with the 4-year-old, but with somebody else.
That's probably what he based it on. Thank you very much.
All right.
Any further presentation?
No, thank you.
Any further questions? Thank you, counsel. You reserve 5 minutes for rebuttal.
Thank you.
Is that the passage that you were basing your statement on, that had nothing to do with the child, the PFA?
Yes, and that would have been in the preliminary hearing transcript. Referencing that in the trial transcript, I believe, is when he was talking about the holiday party at Papakino's and that his son was present with him during that time.
Counsel, if I could take you back to the question of exigent circumstances, why isn't it reasonable for the officers to believe that the simple dissipation of blood alcohol content is sufficient by itself to give exigent circumstances? We're not talking about the circumstance where they're speculating that he may have a second container of alcohol in the house where he's going to go contaminate his own blood alcohol content, but rather just the simple dissipation. I mean, he goes in, shuts the door, and they may not be able to get him out of there within the 2-hour period. Why isn't that enough by itself?
I think that's an interesting point, particularly given the facts of this case with Mr. Keenan, because as it was noted, Mr. Keenan had a bottle of open alcohol in the vehicle at the time. So as much as we talk about the dissipation of the alcohol during that 2-hour window, we also have the alcohol absorption rate. And so if we're going to assume at some point he has stopped drinking, we also have to assume he possibly could still have a skewed result that may go higher. And so I'm not sure during that period of time, given the way the statute was written, it would be deemed appropriate during that 2 hours. And so I don't know that the officers needed to follow him immediately during that time because they did have a 2-hour window.
They would have needed to get a test result within that window.
Unless he would have refused, as he did in this particular
Sure,
case.
but that's in the future.
And so in this particular case, if they believed that were particularly an issue, one, I don't believe they ever asserted that. I don't think that was anything that had been argued by the state, that there was any concern of the alcohol dissipating. I don't believe there's anything in the record to support that as even what the officers were thinking at the time.
Well, isn't that a form of evidence destruction, essentially? I mean, that's what the Court of Appeals relied on, probable cause with exigent circumstances, and talked about evidence destruction.
I think it could potentially be destroyed over that period of time if they were not in a position to be able to gain a search warrant within that period, within the 2-hour window as required by the statute back then.
Was there any evidence in this record about availability of a search warrant, how long that would take, the process of that at this time?
Within the record, I don't believe at the trial court level they had put anything in there on how available the on-call judge was and what the turnaround time would have been to get the search warrant. So I don't think that that was anything that I recall being in the record from trial counsel.
I want to clarify your answer to Justice Stiegel's question. I'm hearing you say that the dissipation of evidence was also simply a possibility because we don't know when he last consumed from the bottle in the car, and that you have two concurrent things happening. You have the absorption of alcohol into the bloodstream increasing, and you have the metabolism decreasing, and those are both going on at the same time. And if he had just consumed some alcohol, he may be on a more absorption than metabolism period, so that it wouldn't be dissipating. Is that what you're saying? That it's not a possibility, or it's more than a possibility, less than simply a possibility, unless we know when he drank his last drink. Is that your argument there?
It is, that this is largely a possibility. We're speculating onto what his behavior was because the officers allowed him to enter the home without following through on even some of that basic questioning. We see routinely in DUI cases, one of the first things they ask them before any person stopped is, when did you have anything to drink? Where were you coming from? When did you last consume alcohol? The officers, whether or not that particular person is honest, because myself, I question whether everyone has 2 drinks and then they choose to drive, although that seems to be the predominant popular number between my clientele is 2 drinks.
2 beers.
They will at least at that point be able to not only create a potential timeline in their mind, but they also then can gauge the honesty of the person they're talking to, because the officers, through their training and experience, do hear the same standard answers that I read through the police reports and that you hear in argument from the same statements being made. Here, I believe the officers didn't even perform those perfunctory questions before allowing him to enter the home, and so they had no basis to know in one direction or the other.
Right, but
That's
we're
not
not.
true, because they had a tip from somebody who observed him stumbling drunk. So they had more information than an officer who merely pulls someone over because of a traffic violation.
And I apologize, I had meant just from the perspective of they didn't know when he had last consumed alcohol, because obviously if alcohol is found in the vehicle, the person who performed the tip can't be accurate in that information either.
They can't be 100% knowledgeable.
Right.
They might be accurate, but they might be accurate accidentally.
We know today from the U.S. Supreme Court's decision in Missouri versus McNeely that dissipation of alcohol is not a per se exigency. The officers maybe didn't know that in 2010 at this time. How does that factor into our thoughts, if at all?
I don't know what we could speculate to those officers knowing at the time, because in all honesty, when we think about it, less from a legal standpoint and more from a practical standpoint, in 2010, we knew that alcohol would eventually dissipate from the system, and we knew that when you would consume alcohol, there was always a curve before you would start to feel the effects of it. Largely, I think we can all adjust to that if we've ever been out and been drinking. And so I don't know that at some point the officer needed the Supreme Court to tell them that's how alcohol works. I think these officers are probably no different than the rest of us and have had alcohol in their life and understand the effect of it. So I think that was more of the court making a ruling towards something that, while backed by science, is kind of a common sense understanding. And so even in 2010, the officers would have been aware of that, although it is not in the record.
You have any more questions?
Counsel, the slurred speech note that I have in here, is that before or after entry?
My reading of the record is that occurred in the hallway after he laid his son down.
Any more questions? What are you asking us to do, counsel?
Your Honor, I am asking the court at this point to remand this matter back to the district court, finding that the court did not apply the correct standard, that probable cause did not exist, and that then, given probable cause did not exist, the exigent circumstances did not apply based upon the factors in the arguments today, and to allow for further proceeding then.
Why do we have to remand for the district court to apply standard if we're going to rule as a matter of law there was no probable cause?
Well, that is, if the court is comfortable making that particular ruling that there is no probable cause, then we would ask the court to overturn the ruling in the Court of Appeals.
Only for,
And-
go ahead.
I would assume then we would have to remand at some point, even if we find there is no probable cause, for further proceedings to determine if the state could move forward with the case, finding that anything that occurred after entering the home had been suppressed. Because obviously, as the court had noted, there would still be the evidence that it occurred prior to entering the home, from the tip call, the observations the officers had, to move forward, and we would like everything, obviously, after they entered the home then to be suppressed.
Any further questions? Thank you, counsel. We thank you both for your arguments this morning. The court will take this matter under advisement.